All right. Welcome back to the Daily Facts. And today we are going to go over the court documents for General Flynn. So this is the government's motion to dismiss the criminal information against the defendant, Michael T. Flynn. All right, so let's get into it. Let's give you a background on General Michael Flynn. He was born December 24th, 1958. That makes him 61. He was born and raised in Middletown, Rhode Island. He was the former national security advisor to President Donald Trump. His education, University of Rhode Island and Golden State University, and he also went to some military schools as well. He has a wife and 2 children, and he is a 3-star lieutenant general in the U.S. Army. Okay. Now, these are going to be some of the major players that you'll hear about as we read through this document, this legal document. So we have Sergei Kislyak, Peter Strzok, Lisa Page, Andrew McCabe, Bill Priestap, James Comey, and Judge Sullivan. All right. So let's get into it. United States of America versus Michael T. Flynn. And before we get into it, I just want to say that this is an important document. I mean, there was the indictment, but this one has all of the information, the reason why we are where we're at right now, why the General Barr has instructed Judge Sullivan to dismiss this case. And Judge Sullivan is doing everything in his power to not dismiss it, but, you know, I digress somewhat. So it has all of the background information in it, and it's pretty fascinating. So let's go ahead and get into it. So again, United States of America versus Michael Flynn. Government's motion to dismiss the criminal information against the defendant, Michael T. Flynn. The United States of America hereby moves to dismiss with prejudice the criminal information filed against Michael T. Flynn pursuant to Federal Rule of Criminal Procedure 48A. The government has determined, pursuant to the principles of federal prosecution and based on an extensive review and careful consideration of the circumstances, that continued prosecution of this case would not serve the interests of justice. Okay, so that's William Barr saying, no, we're done. There aren't any prosecutors even prosecuting this case. It's over. Sidney Powell is Michael Flynn, General Flynn's attorney. And she's arguing, I mean, it's an absolute mess. But let's continue. Mr. Flynn entered a guilty plea, which he has since sought to withdraw, to a single count of making false statements in a January 24th, 2017 interview with investigators of the Federal Bureau of Investigation, FBI. This crime, however, requires a statement to be not simply false, but material false with respect to a matter under investigation. Materiality is an essential element of the offense. Materiality, moreover, requires more than mere relevance or relatedness to the matter being investigated. It requires probative weight, whereby the statement is reasonably likely to influence the tribunal in making a determination required to be made. And they're just citing United States versus Weinstock, 1956, circa 1956. All right. After a considered review of all the facts and circumstances of this case, including newly discovered and disclosed information appended to the defendant's supplemental pleadings, ECF numbers 181, 188 through 190, the government has concluded that the interview of Mr. Flynn was untethered to and unjustified by the FBI's counterintelligence investigation into Mr. Flynn a no longer justifiably predicated investigation that the FBI had, in the Bureau's own words, prepared to close because it had yielded an absence of any derogatory information. The government is not persuaded that the January 24th, 2017 interview was conducted with a legitimate investigative basis and therefore does not believe Mr. Flynn's statements were material, even if untrue. Moreover, we not believe that the government can prove either the relevant false statements or their materiality beyond a reasonable doubt. Okay, a determination to prosecute represents a policy judgment that the fundamental interests of society require the application of federal criminal law to a particular set of circumstances. Justice Manual 9-27001. In the government's assessment, mindful of the high burden to prove every element of an offense beyond a reasonable doubt, and that government prosecutors have a duty to do justice, and that's United States versus Darewu, continued prosecution of the charged crimes does not serve a substantial federal interest. The government respectfully moves to dismiss the criminal information with prejudice against Mr. Flynn. Okay, so here's the background. This is why General Flynn is in the mess that he's in, okay? The FBI opened a counterintelligence investigation into Mr. Flynn on August 16, 2016, as part of the larger Crossfire hurricane umbrella. An investigation into the presidential campaign of Donald J. Trump and its possible coordination with Russian officials to interfere with the 2016 presidential election. Opening the Crossfire Razor investigation August 16, 2016, codenamed Crossfire Razor, the investigation's stated goal was to determine whether Mr. Flynn was directed and controlled by and/or coordinated activities with the Russian Federation in a manner which is a threat to the national security and/or possibly a violation of the Foreign Agents Act or other related statutes. So there you go, statutes that he may have violated. In addition to the predication for opening Crossfire Hurricane, which did not specifically identify Mr. Flynn, the FBI predicated the counterintelligence investigation of him on an articulable factual basis that consisted of 3 facts: Mr. Flynn's service as a foreign policy advisor to the Trump campaign, his publicly documented connection to state-affiliated Russian entities, and the fact that he had traveled to Russia in December 2015. After approximately 4 months of investigation, however, the FBI determined that Mr. Flynn was no longer a viable candidate as part of the larger Crossfire Hurricane umbrella case and prepared to close the investigation. Now, this is where it starts to get hairy. At some point prior to January 4th, 2017, the FBI drafted a closing communication to effect the termination of the case. Okay. Let's see here, interview of Mr. Okay, see example 1, example 3 at 2, FBI FD 302, interview of Mary McCord, July 17, 2017. This document noted, and so that's just the document, okay, that they're outlining there. This document noted the specific goal and predication for the investigation. Example 1 at 2. It laid out the numerous searches of holdings and investigative steps that had each step yielded no derogatory information on Mr. Flynn. Okay, noting the absence of any derogatory information or lead information. It stated that the investigation had failed to produce any information on which to predicate whether investigative efforts, to predicate further investigative efforts. So it didn't produce anything worthwhile. And it was just like, no, we're not, there's no need to continue. This investigation has bared no fruit. Okay, and it noted that no interview of Mr. Flynn was required as part of the case closing procedure. Before concluding, the FBI is closing this investigation. The document also stated, if new information is identified or reported to the FBI regarding the activities of Crossfire Razor, the FBI will consider reopening the investigation if warranted. The document had not been approved, however, as of January 4th, 2017. Before the intended case closing took effect, the FBI learned of communications between Mr. Flynn and Russian Ambassador Sergei Kislyak that had taken place in late December 2016 and which touched on matters of foreign policy. I mean, he was the incoming national security advisor, so, okay. It seems reasonable that he would be having discussions in December. I mean, Donald Trump was now president. Well, he won, and he was going to be sworn in the following year, January 20th, but it was already, you know, he had already won. So he was president, and General Flynn was now his NSA. Okay. Let's see. So Mr. Flynn and Russian Ambassador Sergei Kislyak, which I read, that had taken place in December 2016 and which touched on matters of foreign policy. Okay, so they're starting to say, all right, he sat down with this Ambassador Sergei Kislyak. All right, this is some sort of maybe a potential violation. He had a discussion with him. All right, so let's see, statement of FBI Director James Comey, March 2nd, 2017. Interview of Michael Flynn, January 24th, 2017. By this time, Mr. Flynn had already been named by President-elect Trump, okay, there you go, as his incoming national security advisor. Brian Bender, Trump names Mike Flynn national security advisor, Political, November 17th, 2016. So that was a Political article where it's titled Trump names Mike Flynn national security advisor, and that was November 17th of 2016. And General Flynn, who was for all intents and purposes the NSA director, had a conversation with Ambassador Sergei Kislyak in late December. Okay, but he was the advisor on November 17th. All right. The FBI had in their possession transcripts of the relevant calls. So he's having phone conversations with, General Flynn is having phone conversations with Ambassador Kislyak. Okay, so let's see. The FBI had in their possession transcripts of the relevant calls. Interview of Peter Strzok, July 19, 2017. Believing that the counterintelligence investigation of Mr. Flynn was to be closed, FBI leadership, the 7th floor, determined to continue its investigation of Mr. Flynn on the basis of these calls and considered opening a new criminal investigation based solely on a potential violation of the Logan Act. Yet discussions with the Department of Justice resulted in the general view that the Logan Act would be difficult to prosecute. And there was an interview with Sally Yates, who was, you know, in the Department of Justice at that time. And so basically it's being said that it would be difficult to prosecute. So the FBI never opened an independent FBI criminal investigation. On January 4th, 2017, FBI Deputy Assistant Director Peter Strzok learned that Razor's closure had not been timely executed, and the counterintelligence investigation into Mr. Flynn was unexpectedly still formally open. Mr. Strzok immediately relayed the serendipitously serendipitously good news to Lisa Page, the special counsel to FBI Director Andrew McCabe, remarking that our utter incompetence actually helps us. Ms. Page reacted with surprise and relief. Mr. Strzok, moreover, instructed agents to keep it open for now at the behest of the 7th floor. Mr. Strzok indicated there was a need to decide what to do with him. Other internal FBI messages from the afternoon reflect apparently related conversations about a potential interview. And I heard Pete say Andy and that's redacted, will interview. So just some back and forth possibly between Peter Strzok and Andy McCabe about a potential interview with General Flynn. As of January 4th, 2017, then the FBI kept open its counterintelligence investigation into Mr. Flynn based solely on his calls with Kislyak. The only new information to arise since the FBI's determination to close the case. On January 12, 2017, the Washington Post reported that the December 29 communications between Mr. Flynn and Russian ambassador, let's see. All right, and then it's citing some things here. See David Ignatius, why did Obama dawdle on Russia's hacking? The next day, January 13th, Sean Spicer, the spokesperson for the Trump transition, clarified that the communication had involved only logistics, which seemed to contradict the nature of the calls. On January 15th, Vice President-elect Mike Pence stated that Mike Pence stated in a news interview that Mr. Flynn had suggested that his conversation with Kislyak did not relate to sanctions. Around this time, FBI Director James Comey advised DOJ leadership of its investigation into Mr. Flynn, and senior officials at both the FBI and DOJ had concerns that the incumbent White House officials' descriptions of Mr. Flynn's calls with Kislyak were not accurate. FBI Director Comey took the position that the FBI would not notify the incoming Trump administration of the Flynn-Kislyak communications. Deputy Attorney General Sally Yates and other senior DOJ officials took the contrary view and believed that the incoming administration should be notified. Deputy Attorney General Yates and other senior DOJ official became frustrated when Director Comey's justifications for withholding the information from the Trump administration repeatedly morphed, vacillating from the potential compromise of a counterintelligence investigation to the protection of a purported criminal investigation. So Sally Yates and others in the DOJ, senior officials, they were frustrated because this was not being communicated to the Trump administration, and they felt that it should be. Okay. The Deputy Attorney General, Director of National Intelligence, and Director of the Central Intelligence Agency all agreed that the FBI should notify the incoming Trump administration of what had exactly been said on the calls. FBI Director Comey continued to refuse to brief the White House in a subsequent conversation with CIA Director John Brennan. On January 23, 2017, then Acting Attorney General Yates met with senior DOJ officials, and they again discussed the need to press the FBI to notify the White House. I mean, your guess is as good as mine as to why James Comey didn't want the administration, the Trump administration, and Trump to know, unless he just felt it didn't rise to that occasion. But I can't speak for what was going on in his mind. I don't know. Matters came to a head on January 24, 2017. That morning, Yates contacted Director Comey to demand that the FBI notify the White House of the communications. Director Comey did not initially return her call. When Director Comey called her back later that day, he advised that the FBI agents were already on their way to the White House to interview Mr. Flynn. Acting Attorney General Yates was flabbergasted and dumbfounded, and other senior DOJ officials hit the roof upon hearing of this development, given that an interview of Flynn should have been coordinated with the Department of Justice. So it looks like James Comey is doing things his way and not involving the Department of Justice. He's gone rogue, I guess. In fact, in the preceding days, senior officials of the FBI had been engaged in discussions about how to approach Mr. Flynn and whom to testify and whom to notify. On January 21st, 2017, Mr. Strzok proposed to Bill Priestap, the FBI's counterintelligence chief, that Mr. Flynn should be given a defensive briefing about an investigation under the Crossfire Hurricane umbrella, or alternatively, an interview under light defensive briefing pretext. Mr. Strzok also noted that DOJ might direct us to inform V. POTUS or anyone else, speculating that this could lead to the White House specifically directing us not to speak with Mr. Flynn. On January 22nd, 2017, a FBI attorney emailed Mr. Strzok and Ms. Page that if we usually tell the White House, then I think we should do what we normally do. Though the official also noted that they could be told not to debrief or interview Razor. In advance of the interview, Director Comey determined that they could go interview Mr. Flynn the following day without notifying either DOJ or the White House. In a December 2018 interview with MSNBC and NBC News analyst Nicole Wallace, he stated this course of action was something I probably wouldn't have done or gotten away with in a more organized administration. See interview by Nicole Wallace with James Comey, December 10, 2018. Messages between Mr. Strzok and Ms. Page on January 23, 2017 indicated that Bill had conducted several conversations with Andy McCabe because he wanted to know why we had to go aggressively doing these things openly. All right, so we're going to stop there and we'll pick up again soon. Yeah, very interesting. So thanks for stopping by the Daily Facts, and I'll talk to you again soon. If you feel so inclined, do like, share, subscribe, and leave a comment. Talk to you again soon. Bye.